year for the respondent. And they filed their review petition, Lordship.
The judgment in RSA was delivered by me.
Yes, Lordship.
When do you want?
On Thursday, Lordship, it may be taken up.
Okay, on Thursday.
Obliged, Lordship.
Item number 1.
May I please, Lordship. My lord, POCSO matter, my lord, this person, my lord, is behind the bars for, my lord, 495 days. Long trial case, my lord. Step was taken earlier also, and was on last occasion, my lord, on 7/10/2024, I took a step, my lord.
Whether the notices are served.
I have no idea, my lord. I have already taken a step, my lord.
The official key.
Step received, my lord.
You verify,
Take instruction whether service completed or not.
because there is no office note regarding service of
service.
notice.
2 times I have been taken a step, my lord. Lastly on 7/10. Long trial case, my lord. 40 witnesses are there, my lord.
Heard Mr.
Check that.
S.H. Sigdal, learned counsel for the petitioner, who submits that in pursuant to the directions of this court, he has taken steps for issuance of notice on respondent number 2. Stop. However, there is no office note regarding the fate of service of notice on the said respondent. Then an additional public prosecutor is requested to inquire about the service of notice on the respondent number 2 from the officer in charge of concerned police station, and let this court know about the same on the next date fixed. When?
I don't know. I didn't know anyone. 1911, 1911.
Listed again on 1911.
Hello, bless. ठीक है प्यार अभी हाफ से चले चौथी नंबर
Okay.
जी
Item 5 and 6.
After some time.
Item number 2.
May please. My lord, this is a second application. Your lordship was pleased to call for the update case diary, up-to-date case diary. The application under 482 of the BNSS, my lord, seeking anticipatory bail. Now the offense, my lord, having been committed prior to 1/7, my lord, before coming into force of the BNS. So therefore, my lord, the offenses are registered under the IPC. The 376, 384, 354, 323 IPC. Now, before coming to the FIR, my lord, in long and short, what the informant says.
No, why it was rejected earlier?
Rejected, my lord. In fact, your lordship was after perusal of the case diary, your lordship, my lord, was of the view that there are sufficient incriminating material. So, no, my lord, my respectful submission, this as your lordship had considered this earlier while calling for the case diary. And my lord, having been, my lord, your lordship having been satisfied, your lordship was pleased to call for the case diary. Now, here, my lord, I have some respectful submission because I'll place 2-3 Supreme Court judgment. It's up to your lordship, my lord, regarding the consideration of the, my lord, bail under 438. Because
Second application.
second,
No, I need authorities on how to consider second application on anticipatory bail, not on the First time it was already rejected.
My lord, lordship is absolutely correct. What I'm trying to say, if I can show, my lord, that the
Now, by taking up second time bail anticipatory, I cannot sit on appeal on my earlier judgment. You have, what are the
parameters.
parameters on which a second anticipatory bail application has to be considered? First, you have to enlighten me on that.
Correct. What I'm trying to say, lord, if your lordship is satisfied that having regard to the guidelines laid by the Honorable Supreme Court, more particularly in the Constitution Bench judgment, the first application, my lord, was not in consonance with such guidelines, then perhaps
Appeal before Supreme Court. If I cannot reconsider my own judgment.
no, my lord, lordship is correct, my lord. In fact, on the earlier occasion also, I, my lord, placed before your lordship that the changed circumstances are two. Firstly, in the earlier application, it was not brought before your lordship, my lord. Notice that, my lord, he is a student. He is, my lord, pursuing some course. So this particular, my lord, pleadings and my lord, another, my lord, ground that he is suffering from some ailment. This, my lord, in fact, changes the earlier, my lord, proceedings. So in that view of the matter, if your lordship takes up, my lord, this particular application as a, my lord, changed circumstances, then, my lord, I can place, my lord, those judgments where, my lord, the guidelines of the Constitution Bench, my lord, has been laid down for consideration of, my lord, 438 application. So only, my lord, since your lordship had rejected the bail application only on the ground that there are sufficient materials, there are other considerations, my lord, which, my lord, your lordship required to take notice of, with all respect, my lord, and humility. And if, my lord, after, my lord, if that, my lord, makes not sufficient for your lordship, then I can come back, my lord, with some other judgment, which says, my lord, what are the considerations, my lord, in the second bail application?
You,
Whether or not your lordship can enter into that part.
yes.
Yes.
You come prepared, then come with those judgments.
Yes. But if your lordship permits me only.
Not here in part.
My lord, correct.
You come with those judgments as well as the judgments which we are fixing it as per your own.
My lord.
You suggested it.
Correct. Lordship may fix it on. Is it given, Hussein? 13, na? Lordship may fix it on a, my lord, hearing day. It will be 21st, my lord, Thursday.
Heard, Mr.
SK Talukdar, my lord.
Mr. S.K. Talukdar, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. Learned counsel for the petitioner submits praise for an adjournment on the ground that he has to bring some authorities in support of submissions which he would be making in this case.
Right.
The prayer is allowed. Let this matter be listed again on 21st of November.
Only one prayer. If your lordship comes to the affidavit part, page 14, my lord, he is aged 21 years. Girl is, my lord, elder than him, my lord. She is 23, 24 years. He is undergoing some, my lord, course. Can it be some interim protection till the next date, my lord? Kindly, my lord. Because eventually, if your lordship finds that, my lord, because why I'm saying, my lord, this is a case which was not, my lord, committed, allegedly not committed in a horrendous manner, in a gruesome manner. Because there was, my lord, admittedly, on the face of the FIR, there was some relation between them.
A case where earlier bail application
Lordship
was
is correct.
rejected.
Why I'm saying so, my lord, he is facing some, my lord, examination recently. So to facilitate that, because, my lord, being, my lord, a student, under Article 21, your lordship is aware that now education has become a, my lord, constitutional fundamental right. Only on that count, kindly.
No, you appear in examination.
Lordship,
When is your examination?
my lord, December, my lord.
Where are the documents?
My lord, in fact, this statement is made in, my lord, para 4 that he is undergoing electrical course at Lakhipur Private Industrial Training Institute for session 22-24. It's a 3 years course, my lord.
That is not sufficient
Yes.
to get interim bail. You have to produce materials to
I leave it to your lordship.
that his examination is on so and so day.
My lord, that is correct. That my lord. Obligation.
21st, you have to first satisfy this court regarding the parameters
Of a second bail application.
of a second anticipatory bail application. If you are able to persuade this court, if we jump that hurdle,
My lord,
then
then
only we will.
correct. I
consider.
understand your lordship.
Otherwise,
Lordship is bound by your lordship's order because it cannot review, my lord. I understand. Deeply obliged.
Met with lordship. This matter, your lordship, last time, only 42 your lordship wanted to know about 42 and 41 of difference, my lord. I won the cases, my lord, that 72 hours when it was not informed, my lord. That was my case. And I have gone through the 40 and 42, my lord. In 41, what I find, my lord, it is power magistrate and doing that both day and night. And for 42, my lord, it is only in case of if it is between sunset and the sunrise, my lord. Specifically. And that is why it is open both. And 41, subclause 3 says, my lord, all the powers will be same as per 42.
no. One more difference is that in 41,
Yes.
the arrest and search has to be made under a warrant.
Under by magistrate issue.
Magistrate will be issuing
Authority.
warrant or the empowered officer may authorize.
Yes, right. In that case, madam, no magistrate is not there. Authority is also not. If there is no authority, if there is urgency,
What is the lapse which,
that 42.
what is your, I have forgotten the facts. You have to
Yes.
refresh.
That's my lord. This petitioner is a driver of a private car. He is a salaried person, my lord. He is owner.
He is a what person?
He's salaried driver. my lord,
Okay.
of a private car, my lord. So the owner of the car, my lord, said that you take my guest and you take him to Pathagand area. So I have, as per instruction, I came. On way, my lord, it was intercepted in front of a police station. And a bag was found in the rear side seat, my lord. And in the bag, this contrabands were found,
So in the vehicle which you were driving,
my lord.
in that vehicle, contraband was
Contraband
found.
was found in the rear side seat.
So their case would be that you were in conscious position.
No, that is the question, my lord. That is one part. That is, of course,
One.
conscious possession, not my lord.
What-
Procedure, I am now coming to at this stage, my lord.
Yes.
So last time I have, when I submitted your worship about 15 to half an hour, my lord. My only question, my lord, because it was sunset, after, in between, my lord. And if.
When the seizure was made?
Yes.
At what time?
Yes, your time is, the same. Caesar time,
Caesar list is there. It was 7:30 p.m.
7:30 PM, my lord.
At page?
Page 16, your lost condition, my lord. Page 16. 165 copy, and mine is, my lord, 18. Your lordship will find handwritten 18, and page 16 is typewritten, my lord, your lordship will find date and time of seizure. Middle portion, my lord, before the top to description of seized exhibits. Your lordship got it.
Yes.
6/1/24 at 7:30 PM.
So what is your submission?
Now you can kindly come to 42.
DPS.
তোমাদেরকে বেশি রাখবে They should have more copies for us also, man. No, they don't.
No, you may read. My book copy is coming. You can.
Here's what. Government should always be benevolent, man. That should be ready with some more copies.
One copy was there. I was number code number 18. I was.
Thank you.
Yes,
Yes.
40.
42, my lord. They have done it without authority. My now subclause 2, my lord. 42 subclause 2.
Yes.
Whether an officer takes down any information in writing under subsection 1 or records grounds for his belief under the proviso thereto, he shall within 72 hours send a copy thereof to his immediate official superior officer. Now, what here they have done it, fine, they can do it as per 41, 1, 2, they can do it, fine. Now, the rest part, I am only thinking, my lord, your lordship, that is there or not, whether they have reported to that, my lord. It is only because in order to save from the manipulation, my lord. This check and balance, because in this type of case, procedure is the main thing, my lord. So that's why, because stringent punishment, so stringent compliance of the rules, my lord. So whether this was done or not, this is my case here.
Only that much.
Basically, at this stage, my lord.
40 to 2 has.
My case is also there. I am not in conscious position, but that of course your lordship will say in the trial that will be seen. But procedural lapse is there, my lord. I have a right to get the bail. Because that will go, my lord.
Whether 40 to 2 is mandatory.
Yes, my lord. Your lordship order is there, my lord. Already it is in the file, I think, my lord. Your lordship.
Page.
But no, it is there, my lord. We have given an extra copy or something. সারা 3 দিন হয়ে যাবে এখন বুঝে যাচ্ছে নাম কি আছে পাবে সরিজা বানোয়াইলা নাই তাই একটাও নাই তুমি কেন প্র্যাকটিস ও না কিছু হয়েছে তাহলে কোন লাগে না খুবই লাগে না দিয়ে দাও
Okay. Your main case is your main submission.
Yes,
Plea is that 40 to 2 is violated,
violated.
and therefore you are entitled
And
to pay.
at this stage.
Get
Moreover, that plea is also there, my lord. I'm not conscious position. I'm a salaried person, my lord. I am to, my lord, that is obey the dictation of the Malik, my lord, owner. Owner, I have a specific my case, my lord. Owner sent with his friend, and I have carried his friend to a particular place. Right? Now that bag does not belong to me. It is not my professional, it is not a commercial vehicle. My. Had it been a commercial vehicle, of course I could have knowledge about this. My. It is not commercial, my lord.
Driver.
I am the driver of a private person, my lord.
No, is there any authority how under such circumstances the
No, private
cases
person,
are-
my only question, my your lordship, kindly see, what is my statement subject to your lordship, whether my plea, my lord.
This is similar to a case. I'm giving an example.
My lord.
Suppose there is a taxi driver. I rent a taxi from Paltan Bazaar to Dispur, carrying some contraband with me,
Right.
in a briefcase. Taxi driver may not be knowing that what I'm carrying.
Yes.
He is intercepted near
Right.
Ganesh Guri,
Right, fine, man. That's
and
true.
taxi driver is also made an accused.
Right.
What are the protections available to that taxi driver? Who
That case is clearly available, that protection is available. He does not
no,
have any.
where are the authorities that how to deal with such circumstances?
Oh, that is there, my lord, right now.
There must be some.
That one about a conscious possession. What does it mean? What conscious possession means?
So what is the burden on the prosecution side?
So basically, the first question will come, my lord, whether he had, only thing will come out whether he had conscious possession or not. Because
No,
the
prosecution
driver, I have taken on rent. I hired the taxi.
No, in most of the cases, the prosecution side take the plea
Yes.
that as he's the driver, as in his vehicle contraband was found, he is in conscious
No,
possession.
that cannot always, all the time, my lord, it cannot be.
Putul,
uh,
is
I have dealt with some cases, my lord, just, basic question, this type of case, but they will take the plea. Now, question, your lordship given the example for this book is a taxi, not a private car, my lord. It's taxi, my lord.
okay. Suppose there is
It
a
is
private,
better case than other one.
it is a better case.
Better case.
Assuming that it is a private car,
Right. Hmm.
I give lift to one of the friend of friend of mine who is not direct friend to me, but my friend referred a person that he will be going in your car.
Hmm.
So I gave him lift without knowing what he was carrying. I had to drop him to the railway station. He
So
was carrying a bag. There was no occasion to check that bag.
yeah.
Neither I will ask what you are carrying.
I cannot ask also.
Normal
if
courtesy.
Friend also here.
So, but he was carrying some contraband, and in between there was a raid, and police made me accused. What are the defenses
So
available to me?
only question of conscious possession. Only difference conscious possession.
Now, what the prosecution side will prove?
Prosecution will say since it was found in your taxi, in your car, in your private vehicle.
What
also.
is the defense available to you?
No difference. If so far I am concerned, they had to say whether I had conscious possession or not.
They will say that you had.
No,
consent.
how can it is a subject? It is a matter of trial, my lord. So for investigation will say, my lord. In the investigation, whether my lord this friend.
Because
Now, in
some
my case, my just in my case, what happened, my lord? I am my car belonged to my owner. Sorry, this car belonged to the owner. I am his driver. Owner asked me, "You take my friend to such and such place." I am bound to obey his. I have taken him, my lord. I
But-
don't know anything.
no, but your story may be true or false. Also.
That's true, my lord. That's certainly, my lord.
You may cook up a false story also.
That may be also, my lord. I am not.
So how to
No,
differentiate?
that is a prima facie your lordship will see, madam. Prima facie 30, when 37 comes, prima facie. Two things here, madam. One is on merit, another is procedural lapse. Two things, madam. So your lordship asking me on the merit of the case.
Oh no.
Yes, my lord.
Yes.
On the merit of
But
the case.
in this case, you are pressing for procedural lapse.
Procedural lapse, basically. One of the points I have taken that I have traded. And your lordship will decide the matters on that also, madam.
Which is
procedural
that?
lapse.
Which is that case?
That's Sharija one way. Procedural lapse. And your lordship, what are you also? Look through them. Your lordship, what are However, there are no reason have been taken. They only have second point section. So thereafter, my lord.
No, on that day, their submission, some other additional public prosecutor was there earlier. Their plea was that 42 would not be applicable in this case.
What is my lord magistrate? When the magistrate issues a verdict, then there is no time limit. Maybe during the night, in the morning, in the time, could be any time. So for 41 is concerned. And if magistrate is to issue that. Here is a query, officer suddenly got involved.
Magistrate as well as some other empowered officer can also authorize.
Here it got, suddenly I got information. My friend is taking some contact. What can I do? I have no time to inform the IAS. I have no authority over that. So I am to do it. I did it. Thereafter, I am supposed to report within the within 72 hours. This is the case in the Soha 42. Without any, nothing, I had no time at all, madam. Once I seek for permission, next time I have to wait. By this time, evidence should be my taken.
Okay.
That is the case. So, like a 8, 9 also you was mentioned, madam. Same thing, madam, here. Here also was, yes, here also I am on the same footing, madam. So far procedure is concerned. 41 is completely different than the magistrate madam with authority. An officer also wishes to be authorized. Here without authority, madam, he has done it. But he has no other option, madam. He used to do it. And he did it.
No, Government of Assam has empowered some officers
Yes.
up to the rank of sub-inspector of
Sub-inspector
police.
level one, that is the-
So for those empowered officers, authorization may not be required. Authorization under. So they also have to follow this mandatory provision.
Certainly, my lord, they cannot do it by notification, they cannot take away the right which is given in the statute. They cannot. But they are not above that one. They have to.
So if the arrest and seizure is made under 41, then also your submission is that 42 would be applicable.
Yes, it is not taken away by 41(3) also. My lord. Not defined, my lord. That is authority. Without authority, they can't do it. 41. Yeah, they can do it. Provided.
Okay, I'll go through it. This, you have this bail application 2316. Lutfur Rahman. Okay.
Same point, I am on the same point.
Yes, Mr. Goswami. Anything else? Anything else? Mr. Goswami. Yes, what is your submission? You are not audible. So you are praying for what? No, that prayer you should have made before he made his submission.
I miss some other case also. I had to come this. Nowadays, people see my road here.
You find out who the officer who seized, who made this search, what kind of under what authority he made search, whether he made search under 41, is he an empowered officer, or whether an authorization is required under 42, and then whether 42(2), that informing superior officer within 72 hours, whether that is done or not. You go through the record, and during the course of the day, you let me know. I am fixing it for order. At 2, he'll inform at 2. I may fix it for delivery of orders day after tomorrow. Yes. Okay, or you go through the record, at 2 you make your submission. Oh, okay. Yes, no, that was considered by in the earlier bail application also. Itu Sabodio, PPK.
নালাগে তুমি একটু সাইড হো না এই থাকলেই সাইড হলো তুমি হলো হেল্প করবে অবলাইজ করো
Just a minute. Mr. Goswami, whether Borthakur is there, Mr. P. Borthakur, he handled this matter earlier. Additional PP, Mr. P. Borthakur. You may consult with him. Yes, item 3. What is this? Appeal hearing.
Was also taken from the other side.
Okay, you are ready?
I'm ready, my lord. Ready. Because I've already submitted once, your lordship. I'll just give a ref.
When it was heard?
My lord,
Just a
it
minute,
was-
let me check my notes.
I-
29/9. पेन तो पढ़ लिया.
File, it will be more convenient, my lord.
Okay, just a minute. Okay, today we have time, we will hear it again.
So, my lord, if your lordship takes up the IA, page 51. Primarily, my lord, the main issues are, one is the constant tinkering with the charges by the learned trial court, my lord, kept on altering charges. That is one aspect.
Just a minute. You tell me the gist of the case.
Yes, my lord.
please.
So, my lord, page 51 is the FIR. So the respondent number 2, my lord, he lodges an FIR alleging that on 7/11/2021 at around 8 p.m., his elder daughter informed him that on the previous night, that is on 6/11/2021, at around 11 p.m., the appellant entered their house, took the younger daughter out, and in the FIR, it is alleged that he committed a bad act upon her. That is the FIR. This FIR was, my lord, registered under section 448 IPC.
Whether it is a offense under POXO,
POXO, my lord.
who is appearing?
Mr. D. Gogoi is appearing. He said to start and he will join. He's on his legs, my
He
lord.
will come.
He will come, my lord. He has told me. Come. So FIR was registered under section 448 of the IPC and section 6 of the POXO Act. In FIR, allegation was that he committed bad act. Now this appellant was arrested on 8/10/2021, and from then, my lord, for the last 3 years, he has been in jail. Subsequently, my lord, when the investigation was conducted, the police found that there was no evidence from the medical report. The police found that there was no evidence of sexual intercourse and no injuries on the victim. Victim was around 7-year-old at the time. So police submitted charge sheet under section 448 IPC and section 8 of the POXO Act. Instead of 6, police submitted under 8.
Sexual assault.
Sexual assault. Now cognizance was accordingly taken. But when charge was framed, my lord, the learned trial court again went back to 448 IPC and 4 of the POXO, section 4 of the POXO Act, penetrative assault. So initially, my lord, FIR registered under section 6, charge sheet under 8, now charge under section 4. Then during the course of the trial, my lord, 8 PWs were examined. Defense also examined 2 DWs. Just before pronouncement of judgment, the learned trial court alters the charge to again to section 6, from 4 to section 6, aggravated penetrative sexual assault. Thereafter, the informant is examined, and now when the
That's necessary because of the age.
yes, but then when the court, before pronouncing judgment, changes it from 4 to 6, and then while delivering judgment, convicts me under section 10. 10. So my lord, starts
10 is
10 is aggravated sexual assault. So first thing is that, my lord, this constant tinkering of the what I am required to defend myself, my lord. that itself keeps on shifting. The goalpost kept on shifting, my lord. Starts with 6,
No,
then
but
8,
there is not much difference.
my lord.
Now, how are you prejudiced?
No, my lord.
Because the offense was of you were charged for penetrative sexual assault.
Yes, my lord.
Penetrative sexual
Yes, my
assault. You knew that the victim was less than 7 years.
Yes, my lord.
So that has to be aggravated penetrative sexual assault because the charge was wrongly framed.
Wrong. So the learned trial court, my lord, corrected the charge to bring it under section 6. What I am trying to
And
explain
thereafter, section 6, he came down or
came down to section 10.
that there is no bar in coming down.
Legally, my lord, there is no bar under a minor.
Yes, you please go. What you have to say on this? To Dekhaksun?
Six one incident, 7 1.
Mr. Chaudhary, how much time will you take?
There is no such reason of stopping.
এটা তো authorized to
Oh, PP will be answering you. You are ready, Mr. Kaushik?
তো এটা report নেব না এটা
He's coming only from next month.
She has not recorded her reason for stopping the that particular.
একটা বলবো। Here, my lord, what they are saying, my lord, accordingly after receiving the information, it was authorized.
One is authority, one is
What, my lord, here it is stated that an officer takes down an information in writing under subsection 1 or records grounds for his belief and that to his shall within 72 hours send a copy thereof to his immediate officer. So writing one thing and information another thing. Two parts. Where an officer takes down an information in writing. This is the one. Here. Then in writing, or records grounds for his either he is to write or the records grounds for his belief, unless the point that to he shall within 72 hours. That is where is the my lord.
no. What is that letter? Which
This letter says, my lord, they are saying 42. But contents you was kindly see with reference to the subject above. I have the honor to, that is with reference to DD entry, my lord. I have the honor to report that today a reliable source of information was provided by the so-and-so regarding movement of one whether so-and-so coming from so-and-so through bypass, carrying huge number of suspected drugs kept concealed inside the vehicle. And accordingly, after receiving the information, it was authorized to so-and-so, so Krishna Kolita of Korimganj PS to carry out the operation.
Only intimation.
Carry out the operation that he carried out. Thereafter, he is to report on how 42-2 comes, my lord.
My lord, in this
He
regard,
should say, my lord, we have carried out and we are informing it on.
no, my lord,
After carrying out, he is to inform.
my lord,
the search was made during night,
Right.
during after sunset.
yes, my lord, but the thing is that when there is the scope of escaping the goods, police can, my lord.
Reason has to be recorded.
Recorded.
Yes, my lord, and that is the only thing is that, my lord, I am relying on Surmukh Singh and Karnal Singh's judgment, my lord. And my lord, where he said that substantial compliance is sufficient, my lord.
I don't know.
Because in nowadays circumstances are different. In fact, my lord, I can place the thing that my lord nowadays, even WhatsApp message, because nowadays things are changing, my lord. Wireless
Nowadays,
message.
who made the law?
My lord,
Legislature
no,
or
no, my lord,
somebody
there's a
else?
judgment. My lord, there's a judgment, my lord. I'm on the basis of a judgment, I'm saying, my lord. And the thing is that here is compliance, my lord.
That if you are conducting search after sunset,
Yes.
authorization for such conduct of search after sunset could not be taken, then you have to record reasons. What prompted you to conduct search after sunset?
Yeah.
Those reasons are to be recorded in writing. And those reasons, that writing has to be sent to your superior officer under
Superior officer.
42. So here that there is no mention that the
That was the-
Reasons.
conducted after sunset.
Yes, that is not mentioned, but the thing is that, my lord, there is a substantial compliance of regarding the search, my lord. Because here
Substantial complaints,
is
how?
sufficient. How? Because, my lord, the writing is there, noting is there, authorization is there, and information is there, my lord. And there,
Then why you conducted search after sunset?
regarding their suspect, I have to look into, my lord. Because this is a vehicle which is coming, my lord. This is not a house search, my lord.
No, it is definition, my lord, it comes. Prior information was there.
So what is your submission? You need time.
One day time I will reply. And, my lord, in Shrumik Singh judgment, there is also one word, my lord. Only none, they,
Judgment
yes, my
tomorrow.
lord. Because they will have to
Let
show
him bring-
they have prejudice, my lord. That is specifically mentioned.
That substantial compliance, that portion is applicable before 2001 amendment. Sorry, 2014 amendment. Because the 72 hours was not earlier there.
Subsequent, my lord.
My lord, I am, the judgment which I am talking about, this is 2019.
Okay, bring that judgment. Let him, we'll continue tomorrow.
At 2, my lord.
Okay, at 2. At 2 or after, because I'm in DB.
That's-
After I
that's why I
think, let it be on Monday.
My lord, because
Monday,
tomorrow 3-4 cases are
Monday,
fixed, but my lord.
মঙ্গলবার আছে না?
Any day, আপনার অসুবিধা মতো।
He will assist me on Wednesday.
Okay. Heard Mr. H.R.A. Chaudhary,
Judgment কোনটা দিলা? এটা পাইছেন?
Learned
What did you?
Senior Counsel assisted by Mr. M.A. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. R.R. Kaushik, who praised for some time to produce some authorities in support of submissions made by him. Prayer is allowed. Let this matter be listed again on Wednesdays, 20/11/2020.
My lord. As
It
part
will
of-
come as part. All of it. Judgment to be listened.
But, Shrumik Singh versus State of Andhra.
I will look at it.
Item 5 and 6.
Chamber on dictation. Yes, Mr. Chair.
This, my lord, quashing petition, my lord. Whether only on my lord, co-accused statement, my lord.
That's what I have gone through, Lordship. Lordship has asked me to go through the records, whether not Lordship. I have
Nothing,
not found anything about regarding the co-accused, apart from co-accused statement, other things are not there.
okay.
Lordship.
Suppose your criminal petition is allowed,
my lord.
then
It isn't on trial stage.
no.
Two witnesses have been examined, my lord, independent witnesses.
Then you have to be discharged if
No materials is there, my lord, to frame charge. That is what we have challenged in this, my lord, petition.
ending 482 and 397, you have produced some judgments.
My lord. Prabhu Chawla and my lord,
Then
Prabhu Chawla's judgment, my lord, 2016, 16 SCC 30.
just a minute. What it says?
That my lord, nothing in CRPC, not even Trinity, can affect amplitude of inherent powers preserved in so many terms by the language of section 482. But inherent powers should not.
And your petition, had it been 397, still it is within period of
time,
limitation,
within time,
within time.
yes.
And what is Vijay and another? Or
That
you
is all, that is also on the my lord, same line, my lord. Vijay also, my lord, on the same line, my lord. 397 CRPC is attracted against all orders other than interlocutory orders. Such a view would limit availability of inherent powers under section 482 CRPC only to petty interlocutory orders. In view of settled law, mere availability of alternative derivative cannot be a ground to disentitle relief under section 482 CRPC.
now assuming that your petition is allowed, what will happen to bail application?
Then I will not press that, my lord, because my proceeding will be against me will be quashed, my lord.
Okay. So that is your alternate submission.
My lord.
Okay, heard Mr. B. M. Chaudhary, learned counsel for the, I'll deliver the judgment tomorrow. Heard Mr. B. M. Chaudhary, learned counsel for the petitioner in both the cases. Also heard Mr. D. P. Goswami, learned additional public prosecutor. List this matter for delivery of judgment on 14/11/2024.
My lord.